Hello and welcome back. So I hope you can hear me. Today we shall take a look at the burden and standard of proof, the types of the burden of proof in evidence law, the circumstances where this burden can shift from the rightful bearers to other people, as well as the people who bear this burden in both criminal and civil cases. So what I will refer to is the book we are using today. It's called A Commentary on the Evidence Act by Steve Ouma. This is the second edition, published in 2017. All right, so the whole idea of burden of proof is that whoever alleges must prove. So, and generally speaking, when you are in court, you need to make sure this burden is discharged if you want your case to be won. If you want to win your case, then you have to discharge this burden and prove your case. Okay, whatever facts you are alleging must be proved. So the first type of burden of proof is the legal burden of proof. Now this burden in criminal cases falls on the prosecution throughout, okay, because of the presumption in law that an accused person is innocent until proven beyond a reasonable doubt that they are guilty. So the burden is on the prosecution from the beginning of the case to the end of the criminal case. And the other type of burden is called evidentiary burden. This one is the saying that whoever alleges must prove, and to prove you need to give evidence, okay, sufficient evidence to prove your case or the facts you're trying to prove. So when it comes to the general legal burden, which is the first type, this normally does not shift from the beginning of the case to the end of the case. For example, section 108 of the Evidence Act says that the burden of proof in civil, criminal, or any proceedings shall fall upon the person who would fail if no evidence at all was given on either side. Okay, so this means that in any proceeding, civil, criminal, or otherwise, there will always be the need to determine legal or illegal, so much so that even when no move is made to prove, there will be no neutral position. Okay, there must be a winner and a loser in every case, and the one who would lose if he did not prove is the one who bears the legal burden. So under section 108 of the Evidence Act of Kenya, we see that the bearer of this legal burden of proof in both criminal and civil cases would be the person who would lose the case if no move was made on either party. So in criminal cases specifically, the prosecution bears this legal burden, okay? And of course, I said why? Because the accused person in law is presumed innocent unless and until they are proven guilty beyond a reasonable doubt, okay? So the threshold is very high, okay, for someone to be given that sentencing or to be put behind bars, the prosecution has to do its part to discharge this burden sufficiently, okay? Yeah. So there's a, sorry, excuse me. There's a case now. It's called Woolmington versus DPP. This case explains that it is up to the prosecution, okay? It affirms Section 108 that it is up to the prosecution who bears this burden, and this burden does not shift to the accused. In this case, in Wilmington versus DPP, the accused was charged with murdering his wife. He admitted to shooting her. The defense was that he had fired the fatal shot by accident. The trial court directed the jury that once it was established that she died as a result of the accused act, he had the burden of establishing that it was an accident. So in this case, the accused, okay, Mr. Woolmington, murdered his wife, but he admitted that it was an accident, okay? Now, the prosecution, the trial court directed that the accused had to prove, okay, that it was an accident. But on appeal, the House of Lords held this to be a misdirection, and Viscount Sankey LC stated the law in a celebrated passage in his speech when he said that the prosecution must prove the guilt of the prisoner. There is no burden laid on the prisoner to prove his innocence, and it is sufficient for him to raise a doubt as to his guilt. So he said, throughout the web of English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt subject, that is the guilt, to prove them guilty, to the defense of insanity and subject to any statutory exemption, if at the end of and on the whole of the case there is a reasonable doubt by the evidence given by either the prosecution or the prisoner as to whether the prisoner killed the deceased with malicious intention, the prosecution has not made out the case. And okay, the prosecution has not made out the case and the prisoner must be acquitted, okay? No matter what the charge or what the trial, the principle that the prosecution must prove the guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained. So the prosecution must really pull up their socks in any criminal case to make sure that they discharge this legal burden, okay, and prove beyond a reasonable doubt that the accused is guilty. Failure to which the case fails and the prisoner or the accused, must be acquitted, okay? Now, this is what you need to keep in mind. In criminal cases, the prosecution bears the legal burden of proving a case beyond a reasonable doubt from the beginning of the case to the end of the case, and the accused is in no way required to prove his innocence. Okay, there was a drama I watched about a South Korean drama I watched called Law School, and in the first episodes, okay, it was interesting that this point came across. The lecturer, okay, of a law class was suspected of murdering someone in the school, and he asked his students what he was required to do in that situation. And one student said that he had to prove he was innocent, and the law lecturer was like, no. The professor said, no, I'm not required to prove I'm innocent. It's actually for me to put doubt in the evidence of the prosecution so that they do not discharge this legal burden. to prove beyond a reasonable doubt, and it wasn't up to him to prove he was innocent. All he had to do was put an element of doubt in the case against him. So these things, they are happening on the ground. They are not just existing in a book. That's good to know. So there's a question here: how many witnesses is a prosecution allowed to bring forth in their attempt or in their effort to prove beyond a reasonable doubt? And in this book, Steve Ouma is saying that the prosecutor needs to make available all witnesses necessary to establish the truth, even if that evidence is going to be detrimental to the case, to the prosecution's case. I think this, and in the case where a prosecutor eliminates some witnesses from coming forth or forward, then it is up to the court to feel that those witnesses which have been eliminated could actually have been detrimental to the case, or have been the missing facts that are required to put doubt in the prosecution's case. So we have seen the general rule when it comes to the first burden is that the burden falls on the prosecution in a criminal case from the beginning of the case to the end. That is the general rule. However, as you already know by now, in where there's a general rule, exceptions are just around the corner. So there's an exception to this rule, and that is found in section 111, that where an accused person has knowledge of a matter, okay, a specific knowledge on a matter that is specific or that is only available to him, and that knowledge is necessary in the case, then the accused is required to explain himself, okay? Is required to explain himself, okay? So we are given an example in this case on page 53 in the last paragraph. In a case where an accused was charged with the murder of his spouse. So we have an accused person who was charged with the murder of his spouse. Everyone is killing their wife. He denied the offense, so, and also denied having taken the deceased away with him on the material day. So I remember this example. He said that he only passed by the deceased's place of business and talked with her, but then left and went on his way home. And from that, 7 days later, the deceased was missing. She did not return home from her place of work. Okay, what the court found was to be very suspicious was the fact that this guy, sat in his home calmly, did not report to the police in the required 48 hours, did not do anything, did not even call the wife's parents, his in-laws, to alert them or ask them about his wife, where she was, if she had been there, okay. He sat down, did nothing for 7 days or 1 week, after which he then called his in-laws. So the court was suspicious of this matter, and found that the very act of doing nothing for a whole week, when the wife had not had a habit of disappearing like that before, or did not, that incident had never happened before, made it look like this guy was hiding something. Okay, so yeah, he was found guilty. Okay, so the court was presumed that he knew, okay, what had happened to her, given the way he was acting. The rule in Woolmington is the general rule that the prosecution bears the legal burden. Okay. Okay. So now the evidential burden is the second type of burden. This one is simple. You need something to prove a case. What is that thing? So that's called the evidential burden. Whereas the legal burden is like the legal burden is like a label. Like, okay, you will wear red. You will wear a red dress to the party. But the evidential burden is the actual red dress that you will wear on, to the party on that day. So the obligation to adduce sufficient evidence, okay, is the evidential burden. Whoever bears the legal burden ultimately or simultaneously bears the evidential burden. All right. So this is prescribed by section 109, which says that where within a suit a fact has to be proved, the party to prove that fact is the one who would want the court to believe it to exist. So it's very simple. Whoever bears the burden to prove, okay, it is upon them to adduce the evidence to prove. So it's very simple, this one. Yeah. Like we said, in criminal cases, the prosecution has the legal burden of proving the elements of the offense, but they cannot discharge this burden unless they have sufficient evidence to prove. Okay. Now, a party who bears the legal burden of proving a particular issue will bear an evidential. I said this is simply repeating. Sorry. Okay. Yeah. Now, of course, this is the general rule, but however, we see that every time there's a general rule, there's an exception. So the exception in this case is the burden of proving any fact necessary to be proved in order to enable any person to give evidence is on the person who wishes to give evidence. This is the general rule. When a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any exception, any exemption from the operation of the law creating the offense has the burden of proving that exception. So the thing you need to understand is these things keep repeating themselves. Remember when we said that a person who in the legal, remember we said in the first type of the legal burden of proof that the general rule, it falls in criminal cases, it falls on the prosecution, okay, from beginning to end. But when the accused has special knowledge, then the burden shifts to the accused. Now in this case, it's the same. When the accused has special knowledge, the burden of proving will also fall on him. Also, in another instance is when the accused wishes uh, wishes to let the court know that he is exempted. Maybe there's a certain exemption in an act of parliament exempting him from being liable for that offense. Then it's up to him, the accused person that is, to prove that exemption, okay? And in another instance, we see that yeah, when the question is whether persons are partners, landlords, or are working in an agency relationship of tenants and and landlord, for example, and one party uh, wishes to let the court wishes to allege that the partnership is over or the principal agent relationship is over, then it's upon that person to explain or give the evidence. All right. Another instance is when the question is whether any person is owner of anything which he is shown to be in possession. The burden of proving that he's not the owner is on the person who affirms. So, for example, where someone is found with a property, he is in possession and he claims he's the owner. The burden of proving that he's not the owner is on the person, the opposite party, who is alleging that, who wishes to disprove or who denies the ownership status of the possessor. Okay. Now, another instance is where there's a question as to the good faith of a transaction between parties, one of whom stands to be the one of whom stands to the other in a position of active confidence. The burden of proving the good faith is on the party who is in a position of active confidence. All right. Now, these instances are just some of the few. There are so many of them. You can find them more under page 59. So other instances where the burden of proof can shift, the evidentiary burden can shift from the normal bearer to the opposite party is when a statute has placed that burden of proof on the accused person. Okay, and it can do this either with express words by mentioning it, or imply it, okay, under interpretation. So another instance is where a statute may be construed as imposing the burden of proof, okay. Yeah, this is a repetition again. Another instance is the public policy, okay, where public policy has favored the burden of proof to be placed on the accused. All right, that is another instance. Now, what happens in civil cases? We've seen the criminal cases. In civil cases, under section 112, the same exception would apply, so that where a court forms the opinion that a person, although not required to discharge a burden, is in possession of a fact, especially within his knowledge. So if you forget all these other circumstances, don't forget this one recurring one, which has been repeated in all these instances, both criminal and civil, where a party has special knowledge that the court doesn't know, the prosecution doesn't know, nobody knows except him and God, then he is required to explain or prove, okay, to prove that fact, okay. So this exception has been the one that is applying throughout. So a point to note in this case is where the person, where the burden of proof shifts to the accused from the normal prosecution, okay, normal bearer of the burden, who is the prosecution in criminal cases. Sometimes the burden may shift, but the accused is not actually required to do anything to prove, where during the, maybe in cross-examination, okay, or in during the examination in chief, or during the process of prosecuting, the prosecution was able to prove that fact, which the accused would have been otherwise required to prove. So sometimes during the process of fighting for their case, the prosecution can stumble upon these facts, and can stumble upon evidence that would be proving, okay, what the accused is required to prove to discharge the burden, and that burden will be counted as discharged, okay. All right, so another instance or exception, which is very common and general knowledge, is where an accused person claims the defense of insanity, where he says at that particular moment when the crime was caused, he was crazy and out of his mind, okay? The burden of proving that fact, the fact that he was crazy and not in his right mind, is that burden falls on the accused, okay, instead of the prosecution. So it shifts, the burden shifts also in the case of insanity, all right. Why do you say that? Because a man is is presumed to be sane and accountable until the contrary is proved. So we are all very sane people, even if we look otherwise, unless it is proven in a court of law that we are not in our right minds. So it is the accused who discharges this burden. Please excuse me. So there is a general question in this book when Steve is discussing and comparing the threshold of the burden to prove between the one that would be on the prosecution to prove beyond a reasonable doubt and the burden that shifts to the accused. Are they the same level of burdens? And in this case, a certain House of Lords say that it wasn't the same. So the burden on the accused, which shifts to the accused to prove a point or a fact, is not as heavy or as high or narrow as the one on the prosecution, because the prosecution has to prove beyond a reasonable doubt. So in this case, the burden on the accused, for example, to prove that he was crazy is not as heavy as the one on the prosecution. The burden is discharged by proving on a balance of probabilities that it seemed more likely that due to mental disease, the accused did not know what he was doing at the material time, or that what he was doing was wrong and so could not have formed the intent to kill the deceased. So this is very interesting to see that where the accused claims a defense which falls under an exception to the general rule of burden of proof, the burden is not, the threshold is not as serious as the one, is not as high as the one in on the prosecution to prove beyond a reasonable doubt. So that's interesting to see. So it is enough if the accused can prove on a balance of probabilities that he was crazy, not in his right mind, or due to some mental disease, he wasn't sane during the time of the commission of the crime. So there is a case I think here called the Mark. Is it Mark or I don't know? It's Nathan rules. McNaughton, I think, rules, which prescribe it must be clearly proved that at the time of committing the act, the party accused was laboring such a defect of reason from disease of the mind as not to know, one, that he did not know what he was doing was wrong. The burden is discharged on proving on a balance of probabilities. So it's the same repetition. The facts of McNaughton were that McNaughton had in 1843 attempted to assassinate Robert Peel, then the British Prime Minister. Instead, he shot Peel's secretary, who died a few days later. McNaughton was charged with murder but acquitted on the grounds that he was insane. The acquittal caused some controversy, so the House of Lords asked a panel of judges to review the law governing insanity. The following two rules arose out of the exercise. Number one, these are now the McNaughton rules. Every accused person is presumed sane unless the contrary is proved by the accused. For a successful plea of insanity, it must be clearly proved that at the time of committing the act, the accused was laboring under such a defect of reason as not to be in his right mind. Okay, so he has to have a mental state of not knowing right from wrong. Section 12 of the Penal Code provides a person is not criminally responsible for an act or omission if at the time of doing the act or making the omission, he is, through any disease affecting his mind, incapable of understanding what he is doing. Oh, excuse me, I'm so sleepy. So it is on the accused to prove the defense he is raising, which is in this particular instance if it is the defense of insanity. So he must prove on a balance of probabilities that during the time the act was committed, the criminal act, he was suffering from a disease affecting his mind, and through such disease he was not capable, he was rendered incapable of understanding what he was doing. Okay. All right, so let's move on. You can see we are already 34 minutes in. There's a difference between being legally insane and medically insane. The question of insanity is decided as a matter of law, okay, and not medicine. So it's on the evidence, the law, the interpretation, and not the medicine. Now there's a case here. It's Republic versus Kemp, K-E-M-P, where the accused suffered from arteriosclerosis. There was a difference of medical opinion about how much this disease affected his mind. The court held that whichever medical opinion was accepted, the disease was one capable of affecting the accused's mind, and so was a disease of the mind within the McNaughton rules. So for any case claiming the defense of insanity to succeed, it has to pass the test in McNaughton rules, the one we have mentioned. He has to have suffered a disease, and that disease rendered him incapable of understanding right from wrong. So it was irrelevant in Republic versus Kemp. It was held that it didn't matter that the disease was one recognized medically as a mental disease or not, as long as it passed the McNaughton rules. That one, oh my God, excuse me. That one was it will pass, okay? Now, in another case, in R Republic versus Hennessy, okay, the accused was charged with taking a vehicle without consent. He was a diabetic who, despite needing to take insulin every day, had not done so for 2 or 3 days before the incident. He was also suffering from stress. He claimed that as a result of all this, he did not know what he was doing, okay? Excuse me, and so he did not have the requisite mens rea. The judge was of the opinion that this was a disease of the mind within the McNaughton rules and that the defendant was insane. The case is an excellent illustration of how the test of insanity is legal and not medical, as a diabetic would not in most circumstances be considered insane. It is also a good example of how in law a person can be temporarily insane. In other words, the law takes the view that it is possible for a person to be sane most of the time, but suffer bouts of insanity. The McNaughton rules only require a defendant to be insane at the time of committing the act. Okay, I'm laughing. I'm laughing because this case right here, Republic versus Hennessy and Republic versus Kemp, by removing the connection of insanity from the medical qualification of that disease or that state of mind, I feel for me leaves a big room, okay, for people to claim they were crazy. And the fact that you can be crazy only at certain times, but not every time, that you can be crazy when you're committing the act yesterday at 10 p.m., but 1 hour later at 11 p.m., you're completely fine. It leaves a room, okay, for the accused. It gives the accused a lot of room to wiggle around, okay, to escape like an eel, as a slimy eel from the hands of justice. Yeah, another example of such a situation is given here by Steve Ouma in this book as an epilepsy or an epileptic fit. we know an epileptic fit is like a momentary episode where someone who is suffering from epilepsy goes into this seizure, and their eyes are like all the way up and stuff. So even that example can pass the Magnatin rules test, where it shows that the person, because of that fit, was unable to understand during that moment what he was doing. Yeah. Yeah, so there must be two things. There was a disease, and this disease affected reasoning. So the person couldn't tell right from wrong during that particular moment. Okay. Okay, so now we know exactly what is going on here. When it comes to insanity, two cases, Republic versus Kemp, Republic versus Hennessy, both, and the main one, the Magnatin case, okay? So both have all of them, they explain that insanity is legal, not medical, okay? And it can be momentary, not have to be throughout, okay? Like a long period of time. And it will only matter where the person was insane when the act was being committed, okay? So another exception here we have is okay, another instance here we have is intoxication. When used as a defense, the burden shifts to the accused, okay? The burden lies on the accused. So the penal code prescribes that intoxication will not be a defense in a criminal trial. But where it amounts to insanity or it was sufficient to negate mens rea, the accused will not have committed that offense. So intoxication alone, like you say you are drunk and you didn't know what you, intoxication has that threshold it has to meet. If you can prove as the accused that you are too intoxicated to be in, like you are so intoxicated as to be crazy, okay, insane, okay, then that your case could pass. So we are given a case here so we can better understand. Steve is telling us that in a case where the appellant was convicted because he killed his wife in a state of advanced intoxication, he appealed. And the court held that while the plea of intoxication is a matter for the defense, there can be independent circumstances pointing to such a position of intoxication arising out of the prosecution case which the court should take into consideration. The court observed that use of a lethal weapon may be an indicator of malicious intent, but it is not conclusive proof of intent in a case of murder. So it's interesting to see here that where the accused does not raise the defense of intoxication, the prosecution bears the burden, okay, of proving that he was, okay, that he was guilty, okay. But where the accused raises the defense, okay, but where the accused raises the defense of intoxication, then it is up to him. But really, this is quite confusing. It's not as straightforward as the insanity exception. So I'm going to move forward, okay? So under page 67, we have another exception apart from intoxication and insanity. It's called express statutory exception. This is what I had mentioned just briefly, where a certain act of parliament or a law exempts the accused from the punishment or from being liable for the crime for any reason, expressly or by implication, then the accused has to prove that particular section of that particular act, okay? Another instance, we have for example, we are given examples of such acts, okay? Section 15 of the Immigration Act, it provides that where there are legal proceedings for the purposes of the act, the question of whether a person is Kenyan or not arises, okay? Okay, a person contending that he is Kenyan shall be the one to prove such citizenship. And the standard of proof shall be on a balance of probabilities. That is one. Number two, Section 9 of the Stock and Produce Theft Act. This section provides that any person who has in his possession stock which may be reasonably suspected to have been stolen will have the burden of proving that he came by the stock legally. Another situation under Section 20 of the Public Order Act, this section provides that where a person is charged with an offense under the Act, the burden of proving a lawful or reasonable excuse will be on the person pleading such an excuse. Okay, so those are some of the acts. There are more, of course, like the Prevention of Corruption Act. Okay, which says that any money given to a public servant shall be deemed to have been paid for corruption purposes, unless the contrary is proved. All right, and the one who has to prove, of course, is the person against whom such an allegation has been made. The Public Health Act. Every person suffering from a venereal disease So any person who is suffering from a communicable disease, okay, and continues to work, if he works in a factory, a restaurant, hotel, house, where he will handle food, children, okay, food utensils, anything that will be consumed by a person, that person is proven guilty. It is as if he did that on purpose to infect people, unless he can prove that he did not know at that moment he was sick, okay? Another act is Wildlife. So Wildlife Conservation and Management Act, where it says it is an offense to be found with or be dealing with game trophies. All right. So if you're found with buffalo meat or lion, elephant's meat or something, or sorry, they are trophies, like we are found with an elephant's tusk, you know, it is an offense, okay? The onus of proving that any possession or dealing was lawful, all right, shall be upon that person. And also when it comes to negligence, where there's a case for negligence, the cause of action is negligence, the burden is always on the plaintiff to prove that the accident was caused by the defendant, the negligence of the defendant. However, if in the trial there is proved a set of facts which raises a prima facie inference that the accident was caused by negligence on the part of the defendant, the issue will be decided in the plaintiff's favor unless the defendant's evidence provides some answer adequate. Okay, so this I think is making sense. So as a plaintiff, you are entitled only to win in an action for negligence if you can prove there is negligence on the part of the defendant. But now, where the defendant, okay, so in a civil case, it's the burden of proving lies on the plaintiff, but it shifts in an exception circumstance to the defendant, where he's trying to prove that the plaintiff, okay, the plaintiff was negligent on his part, okay. I don't know if that makes sense. Now, another act is Weights and Measures Act, Section 29. Okay. This is confusing. It's about weights and measuring instruments. Okay, let's leave that one. When another instance is when an accused puts forth an alibi as his defense, an alibi that at that material time you couldn't have been on the crime scene, or you couldn't have committed the crime because you were not there. Instead, you were with John enjoying a birthday party somewhere. All right. So when you put forth an alibi as your defense, it falls upon the prosecution to disprove it, since an accused person is under no obligation to prove his innocence. So this is not an exception. This affirms the general rule that in a criminal case, the burden of proving falls on the prosecution. Now, except in two defenses, like the intoxication we saw, and where the accused claims he was crazy. Now, where I'm going to repeat the point of negligence. Now, in an action for damages, in this book, it's explaining where a person was injured in an accident, and based on negligence, the burden generally falls on the plaintiff to prove that the accident was caused by the negligent conduct of the defendant. However, if in the course of the trial they have proved a set of facts which raises a case that the accident was caused by negligence on the part of the defendant, the issue will be decided in the plaintiff's favor unless the defendant's evidence provides some answer adequate to this place. So the defendant in this instance can prove that he wasn't negligent in a civil matter. And when he does that, then obviously he has discharged the burden. All right. Now, another exemption here we see, I'm hoping it's the final one. I really hope it's the final one because I'm getting tired and time is up. Let me just confirm. Okay, it is the final one. This exception is res ipsa loquitur. So res ipsa loquitur, which translates to mean the thing speaks for itself. Okay, as it is commonly called, is a rule of evidence that creates a rebuttable presumption that the defendant was negligent, which arises upon proof that the condition causing the injury was in the defendant's exclusive control, and that the accident was one that ordinarily does not occur in the absence of negligence. So this doctrine of res ipsa loquitur makes the defendant bear this burden to show absence of negligence on his part. All right. All right, time is up. Thank you. That will be all for today. Let us move on next time. Thank you.